Most of these protections are found, for example, in the Bill of Rights, Amendments 1 through 9, and specifically First Amendment freedoms. So when you try to differentiate the two, it's against government power. If you look at the wording of the First Amendment, Congress shall not prohibit. It's telling them they can't do something. Freedom of speech, press, petition, assembly, and religion. So that is one way of trying to differentiate why these things have different meanings. Civil rights, on the other hand, are positive actions taken by the government to promote individual rights. All of these civil rights acts tried to limit discrimination by outlawing certain things, whether it is in the workplace you cannot discriminate because of race, whether it's in public accommodations you can't, whether it's everybody has the right to register to vote, and removing barriers such as the grandfather clause, literacy test, etc. When you look at civil rights are usually done in Congress by making laws, through the courts, through interpretation of decisions on court decisions, sorry, that was sort of redundant, and by executive order. And civil rights really protect groups who have been discriminated against in the past. So as you look through your notes, I've chunked it up into several segments. There is one on the rights of African Americans in the civil rights movement with Martin Luther King. And I have listed several laws, several court decisions, and several executive orders that have helped further the cause of African Americans and equality. I talk about women's rights. There is a portion on homosexuals and rights that exist that can't be discriminated on based on sexuality. I've also looked at Asian Americans and rights that they have, as well as age and what was my other one? Handicap, with the Americans with Disabilities Act. So these are just some different areas when you chunk it up. The first part, what I'm going to talk about, is how these freedoms have been nationalized, and then that last portion, probably in another segment, will deal with civil rights and how the government has tried to take proactive steps. So this is really how these two things are chunked up. So what I want to talk about first is civil liberties, and you guys know the background. The founders basically wanted to limit federal powers and assure the rights of citizens against the national government as well as state governments. And a lot of, like, for example, Missouri's Constitution, Article 1 is Missouri's Bill of Rights, because remember, the first original 10 amendments protected us against national power, not states. So states wrote these liberties into their own constitutions. The Constitution's principle is that it is a document of what the government can do, not what they can't. So the Anti-Federalists wanted those provisions in there. I want it written that the government cannot deny my right to bear arms. I want it written that the government cannot search and seize without power. And so that's how the Bill of Rights came about. Here is a basic overview of examples of civil liberties that exist in the original Constitution before the Bill of Rights were added. Things such as Article 1, Section 9, what the government cannot do. And I know you can read those. We've gone over those before. In Article 3, it says there should be a trial by jury. It also defines treason in case anybody does go against the government. The next topic here is very, very important, and I can't emphasize this enough, that civil liberties are not absolute. And oftentimes you have two liberties that come into conflict, such as the right to say whatever you want, which is freedom of speech, and the right to print certain things, which is freedom of the press. So when rights conflict, sometimes it's the right of an individual versus a society as a whole. And when conflict happens, the courts have to step in to balance that power. And through the years, sometimes the court can sway back and forth, but overall, that concept of let the decision stand on what has been based on in the past, that stare decisis, sometimes precedent wins out. I want to spend a moment to talk about this very important topic, and I'm going to write this down. The AP test has consistently dealt with this topic. The nationalization of the Bill of Rights is also called selective incorporation, and it's also called the modifying effect of the 14th Amendment. And I feel like I've stressed in class over and over again, there are two due process clauses in the Constitution. One that protects us against the federal government, that the federal government cannot deny life, liberty, and property, and one that protects us against state power. After the Civil War, remember, those were written in. I'm running out of room on my thing. So I'll put it up here. State power, which is the 14th Amendment, and it also has the Due Process Clause. So these two are the ones that are there. When this 14th Amendment was added, it greatly increased citizens' protections against state governments. And they made many of the Bill of Rights apply to state governments. And I want to show you this selective. It doesn't mean all. It just means on a case-by-case basis, how have the Bill of Rights through the years been applied to the states? And so I just said that statement right there. And what this says is the Supreme Court did not originally extend protection of civil liberties in the Bill of Rights. There was one case, Barron versus Baltimore, which was one of the first cases, and it said, you know, it did not. It just applied against the national government. And originally the Supreme Court ruled quite strictly on this. Because most states had their own Bill of Rights, the Supreme Court felt like it didn't have the power in the Constitution to do that. But look at this year. It's 1833. It's before the 13th, 14th, and 15th Amendments were even added to the Constitution. And when that 14th Amendment and that state due process clause was added, it changed things. So I want to go to the next slide, and let's look at the 14th Amendment and a little background. The 13th abolishes slavery. The 14th, the two main things, and I want to add another one in here as well. Let me just put all this up. There are several provisions of the Bill of Rights that I want to make sure that you understand. I'm sorry, the 14th Amendment. This says right here, no state shall make or enforce any law which shall abridge the privileges and immunities, that's a privileges and immunities clause, of citizens of the U.S., nor shall any state deprive any person of life, liberty, or property. Anytime you see those words, that means due process, that the government cannot take away life, liberty, and property without going through a trial and being questioned and having the right to a lawyer. The second one, and I know you can't see it on this right now, but probably on your PowerPoint, is that it says, nor shall any person be denied within its jurisdiction the equal protection of the laws. This is the second clause that exists in the Constitution. And I'm just going to write a little thing up here. This is called the Equal Protection Clause. The AP test loves these two. So if I can say what two clauses exist in the 14th Amendment, it's the due process against the states, and it's equal protection, the Equal Protection Clause, meaning that every person in the United States is protected equally before the law. And this is where many of our civil rights cases have gained ground and momentum. They sue through the 14th saying, I am not being treated equally like a white male would be. And so issues on race and gender and age and marriage are often filtered through the Equal Protection Clause. So I'm going to explain those as we go on, but I still want to stick to this nationalization clause just for a moment. So let's go to the next slide. In this portion it says, all states must provide all citizens due process and equal protection rights, thus beginning the process of incorporation or national standards onto state legal codes. In 1925, there was a court case called Gitlow versus New York. It was the very first case to incorporate the Bill of Rights against the states, and technically it overturned this precedent of Barron versus Baltimore. That was the original one almost 80 years prior that said that speech that the state governments didn't have to rely on that. And Gitlow was one of those ones that said, you know what, this First Amendment provision by the national government is going to be filtered to the states. The Supreme Court extends the Bill of Rights on a case-by-case basis. How do they do this? Many cases are extended through the 14th Amendment's Due Process Clause and Equal Protection Clause. So you have to ask the question, why do we have to extend the Bill of Rights against state government if state governments already have a Bill of Rights? This question right here, we have to make uniform the interpretation of the Constitution. Therefore, many states do not have exact coverage of certain rights. You can't have rights in one state and not in the other. So the national government was making that uniform. Also, there have been different interpretations of state constitutions, and you can't have that going for every citizen on protections against state government. So that's why the Supreme Court saw a need through the 14th Amendment to interpret it thusly. This is a chart of the 14th Amendment and the Bill of Rights and how the Bill of Rights over time have been applied to state governments. The very first case, as I said earlier, the Gitlow versus New York case was a freedom of the speech case, which made this portion of the First Amendment apply to state governments. The religion case in Everson versus the Board of Education, and I put this in a summary, was the first time that the Supreme Court ever said, yes, this principle that the state cannot sponsor religion also goes to state governments. But remember, it has to be filtered through this 14th Amendment. There is not one court case that would deal with all of these amendments. It's just impossible. So therefore, they've gone on a case by case. The Second Amendment is not nationalized, nor is the Third. We've talked about Mapp versus Ohio. Mapp overturned a court precedent called Wolf versus Colorado. And in Wolf, it said that the state governments it dealt with the exclusionary rule, and Mapp basically said, you can't do that. If state police take evidence illegally, basically, they can exclude that evidence, even if condemning from a court of law. And I think you might get the sort of notion now, Fifth Amendment, but these portions are not yet nationalized. Most of the Sixth is nationalized, not the Seventh, not the bails and fines, and not the Ninth, or portions with the right to privacy. So I find it quite fascinating that the 14th Amendment is this far-reaching and has really made a huge difference in citizens' rights. Provisions not, I just went over these. I just put the topic rather than the amendment. And just think of these questions. Do you think any of the rights listed should be naturalized or nationalized? Why or why not? The Second Amendment protects the right of each state to form and keep a militia. Many believe that the Second Amendment also sets out an individual right to keep and bear arms. There's only one major court case on the Second Amendment, and they've had more recent ones, but not that it's nationalized. And I think it's clear that the court is still upholding the Second Amendment to be a national provision and not forcing that onto state governments. All right, I'm going to stop there with this portion, and I'll talk about civil rights and equal justice under law with the remaining amendments. But please understand this big provision of nationalization or selective incorporation or the modifying effect of the 14th Amendment. The 14th Amendment has been huge in protecting citizen rights.